Good afternoon, everyone. Am I audible to everyone? You can just post in the comment. Can you all please post in the comment if I am audible or not? Students, okay, so I have, okay. So today we have our rapid revision class on limitation for MP Judiciary. Before I start, I'll like to give you all some important sections and articles related to that. So just wait a minute. If you all can see my screen, please comment. Those who cannot, please comment that you cannot see the screen. Otherwise, these are the important sections and articles for Limitation Act, and the ones which I have marked, I've highlighted are the important sections for MP Judicial Services preliminary examination and also for mains, right? Now, sections and articles are really important. If you see Limitation Act, it is divided into sections and schedule, right? The schedule contains article where the limitation period is given. We will come to all that. Which Wish is unable to see. Okay, okay. Let me just check. Wish, is it still not visible? Is it visible to everyone? Is it visible to everyone or not? Vishwesh, can you see now? Screen is visible? Correct. Vishwesh, are you able to see the screen now? Yes. Are you able to see the screen now, Vishwesh? So I'll just show you all the important sections and articles. See, please note this down. Section 3 is really important. 4, 5, 6, 9, 12, 14, 15, 18, 19, 21, 25, 26, 27. Now, these sections are really, really important. I will also highlight this 26 and 27, right? So, from section 1 till section 27, if you see, you will find that these are important sections. These 13 sections which I have filtered out, you cannot miss. It's blur. Okay. Is it okay now? Is it visible to everyone and clear? Is it clearly visible to everyone or is it blurred still? Fine. For those to whom the screen is appearing blur, I'll just repeat the sections so that you all can copy that down or mark it down in your Bare Act. Now, if you see the Bare Act of Limitation Act, right, just see the content side, open the content side and start marking these important sections which I'm repeating. Those who can see my screen, please note it down. Those who cannot, Please follow what I'm saying, and if you cannot, just ping it in the comment box. Section 3, 3, 4, 5, and 6. So from section till section 6, it's really important. Then skip to section 9. Come to section 9. Section 9 is also important. Section 12, 14, 15, 18. Also mark section 17. Students, mark section 17 also. Right? Mark section 17 also. 18, 19. Come to section 19. Mark that also important. Then section 21 and 25. Section 21, 25, 26, and 27. Now these 14 sections are really important from these 32 sections. So please go through these 14 sections. I guess you all can quickly go through these 14 sections in one day only if you study properly for a day. Now come to the schedule part, and we will just mark which are the important schedule. Which are the important articles in the schedule, right? So there are some which I have already written here, but still I'm repeating. 42, article 42, article 52, 54, 42, 52, 54, 59, 60, 61, 63, 64, 65, 61, 63, 64, 65, 67. Then come to 75 and 76, 78, 75, 76, 78. Then 93, 96, and 97. 93, 96, 97. 102, 105, 107, 109, 110. So 102, 105, 107, 102, 105, 107, 109, 110, 112, 112. Then come to 113, 115, 116, 118, 120. Those who can see my screen, please mark this. 113, 15, 16, 18, 20. 121, 122, 23, 27. Then 130, 133, 135, 137. 130, 133, 135, and 137. So please go through these articles also along with the section. Just you can go through the period of limitation given in all this article. See, they generally don't ask which article, but if they really want to, create a very cut-off kind of and competitive situation, they might also ask the article. But these articles are really important. You cannot miss. Is this clear to everyone? Have you all marked the important sections and articles of limitation, which I have just told you all? Vishwesh, Prachi, can you hear me? Okay. So before I can move on to the before I can just move on to the section wise explanation of Limitation Act, first I like to discuss the object of limitation. So I feel that no one can understand Limitation Act without understanding the object. You cannot understand any statute without understanding the object of the act for what it was enacted. The object for which it is enacted is actually reflected in all the sections. So if you are very clear with the object, you can relate that in every section. Okay, this section is, fulfilling this object. So this is how you can move on. So first, when when you hear this term limitation, or when you come across this term limitation, because the act is limitation act, so we need to understand what is limitation. We always understand that limitation is something which is actually restricting you, right? It's a rule of circumstance which is limiting or restricting your movement. So here also limitation act is actually something which is restricting someone's movement to file a suit after a certain period. So there is always an expiry date to everything. Even we have an expiry date. So we cannot allow any suit or any application or any appeal to be immortal. We can say we cannot allow anything to be immortal while we are mortal, because human beings are mortal. So we also need to see that other things also have an expiry date, right? So limitation act, if you see, it's a procedural law, or you can also say that it's an adjective law, which is actually prescribing a time limit for everything, right? So there is, what is it restricting you in? It is limiting you in time limit, right? Within which the aggrieved party can seek remedy in a court of law. So what is it restricting you in? What for what thing is it giving you time limit? If you see, if you go to any mall or if you go to any place, you see whatever food packet you buy, whatever things you buy, they all have an expiry date, right? So here for suits, for application, for execution, for many other things also, uh, you know the drafters and the lawmakers, they understood that we have to give a expiry date, otherwise this will keep lingering on a person, and the person will always be in a situation where a sword is hanging, that any day someone can just come up and file a case against me. So we don't want to do that, right? Limitation act is prescribing expiry period after which you cannot institute a suit, after which you cannot file an appeal, or after which you cannot make an application, right, in a court of law to seek your remedy. Yes, you have the right to seek remedy, but only till a certain period. You have to be very vigilant towards your right. You cannot sleep over your rights. So today, if someone has done something against me, if someone has harmed me, or say for example, someone has defamed me or beaten me, I do have a remedy in the court of law. I can go to the court of law, but they also say that you cannot come after an expiry date. So you have to be very vigilant when your rights are concerned. You cannot be sleeping over your right. This is the concept. You cannot sleep over your rights. If you see the act, right, section 2 has all the meanings, all the definition, where limitation, this period of limitation has been defined in section 2J, right? Period of limitation, which is given in the schedule. And see, there are two things which you have to understand. One is the meaning of limitation, one is the meaning of prescribed period, and one is the meaning of period of limitation. So period of limitation is the time limit for which you can, after which you cannot institute a suit or prefer an appeal or make an application. Whenever you are using these words, be very sure about what words you make. So you cannot say I want to make a suit. No, you have to institute a suit. The word for suit is institute. So you don't say I will prefer a suit or I will make a suit against you. No, I will institute a suit against you. Similarly, when we say I want to go for appeal, so I won't say I will make an appeal against him, or um, I'll make an appeal against this decision, or I will, institute an appeal against this decision. No, it is always prefer. The word used for appeal is prefer. So I would like to prefer appeal, right? And for application, we will see the word make. So you have to make an application, institute a suit, prefer an appeal, and make an application. These are the words you will find in the sections also. So there is a difference between period of limitation and prescribed period. Period of limitation is the time limit for a suit, appeal, or application which you will find in the schedule. As I told you, the act is divided into sections and schedules. So you will find all the time limit in the schedule. Okay, the period of limitation. And prescribed period is the period which is computed, which is calculated after you follow the rules and regulation which is given in this act. Whatever time limit is coming, which you can compute or which you can calculate, that is your prescribed period. Now there is an object of limitation act. What is the object of limitation act? See, limitation act is a statute of repose, peace, and justice. Please write it down somewhere. These are important points. So, Limitation Act is a statute of repose, peace, and justice. Please note it down. Right? So, why is it a matter of repose? Why it is a matter of peace? Why is it a matter of justice? How can you say it's a matter of repose, peace, and justice? Now, anything which is giving you, what is the meaning of repose? Can anyone tell me the meaning of repose? What is the meaning of repose? It means to relax, right? So by prescribing a certain period, by giving you all an expiry date for instituting a suit or preferring an appeal or making an application, limitation act is actually making the people, giving a feeling of relaxation that okay, 3 साल हो चुका है, अब इस 3 साल के बाद कोई सूट मेरे अगेंस्ट नहीं हो सकता इस मैटर के लिए, बिकॉज 3 years has already passed, and the court, if you go to the court, it is going to bar your suit because of limitation period, right? There will be a bar of limitation. That is why it is a statute of repose, because it gives a kind of relaxation to those people who are in constant fear that they have done something wrong, or someone might institute something against them. So for that, it is a matter of repose, right? Because it is barring the suit after a certain period. Now it is there to quiet long position and extinguish stale demands. Please note this down also. Limitation Act is actually giving you a expiry date so that it can quieten long position and can extinguish stale demand. So it is giving you peace, it is giving you security, and it is giving you justice also. Because I cannot allow a person to be in a constant doubt, dispute, or uncertainty that any day, a suit might come up against me from nowhere. I was not expecting it. So much time has gone, but now you are, coming up with a suit. And I have lost all my evidences. I took through all the papers and everything which you have which was there with me as a proof. I have already thrown that, right? Or I have already lost that, or maybe in my memory I don't even remember. So now when you are coming up with these things, all my evidences and proofs which I had is actually lost. I deleted all the pictures, or I deleted my WhatsApp messages concerning the same, because I thought now it's gone. It won't be coming up. But now you're coming up with these suits or appeal or application. That is why law is giving you that right, that you cannot be in a constant state of doubt, dispute, or uncertainty. Why? Because human beings needs to prosper. They have so many things to do in life to make their future, and by living in this constant uncertainty and doubt, you know the the thing that a man will grow is actually limited. So we don't want that there is a limitation in the growth of people, in the development of a person's a person's personality, and his contribution in the society by living him in a constant state of doubt, dispute, and uncertainty. That is why it wants to extinguish stale demands and want to quieten long position. Now there are uh, two very important maxims which are on which the statute of limitation is based. If you all know the maxim, you all can write that in the chat box. If you don't know, I can just show you my screen. It is here also. If you can see this box, this lavender box, right? The So this is my two public policy maxims on which my limitation act is based. So first is interest republicae ut sit finis litium. Interest republicae ut fit finis litium, which means it is in the interest of state to bring an end to litigation. So it is in the interest of state to bring an end to litigation. Interest republicae ut sit finis litium. Second is vigilantibus non dormantibus jura subvenant. Vigilantibus non dormantibus jura subvenient. That means law asks you that be vigilant, right? And it will assist those who are vigilant and not those who are sleeping over their rights. Clear to everyone? So these are important things you have to understand. It's a statute of repose, peace, and justice. It is there to quieten long positions and extinguish stale demands. There are two maxims which I have just told you, right? So it is in the interest of state that there should be an end to litigation, and law will assist only those who are vigilant and not the ones who are sleeping over their rights. Clear to everyone? Right? So I cannot allow long dormant claims to be there, because long dormant claims will have more of cruelty than justice. ठीक है, माना मैंने कि चलो I will give you unlimited period to file a suit, but you know that will have more of cruelty than for justice, and we want justice. The object of law is to give justice to people, but long dormant claims and stale demands will have only cruelty and not justice, right? So we cannot leave the defendant hanging over that doubt that a claim can come, any day to him, right? Because a defendant might have lost evidence to disprove the stale claim due to loss of documents, due to death of witnesses, due to fading memory, etc., etc. And so any person who has a cause of action, who has a genuine cause of action against another person, should pursue it within reasonable time and with reasonable diligence. Don't sleep over your rights. Be vigilant, not dormant. Clear to everyone? Is this clear? Right? So these are my object. And the object of law is always to give justice, right? Is always to give justice. So everything, every act which is framed always sees that, okay, we want to give it for justice. Because unnecessary delay in filing a suit, an unnecessary delay in filing a suit will only result in loss and destruction of evidence and documents. Right? So these are the important objects which you have to go through in detail when you are reading about the object, right? And why is there is a necessity for putting a limit to litigation? Because of the perishable nature of man, because we are mortal, we cannot allow suits and claims to be immortal, right? And remember one thing, law of limitation is based on it's based on public policy. Now let us come to the act. I hope everyone has the Bear Act with them. Otherwise, I'm going to share my screen also. Hope my screen is visible to everyone and clearly visible to everyone. If not, please open your Bear Acts also, so for better and convenient method, to understand whatever I'm trying to teach here. Has everyone opened their Bear Act, or can everyone see my screen? Those who don't have the Bear Act with them right now can see my screen. And those who have the Bear Act, please open the content part. तो आप देखो, लिमिटेशन एक्ट 1963 कैसे डिवाइडेड है? Into how many parts is it divided? It's divided into 5 parts. Please see the parts, student. There are 5 parts of Limitation Act. Part 1 is preliminary. Part 2 is limitation of suits, appeals, and application. So it's dealing with suits, appeal, and application. Part 3 is computation of period of limitation. If you see part 3, it's computation of period of limitation. Part 4, acquisition of ownership by possession. Acquisition of ownership by possession, very important, part 4. Part 5 is my miscellaneous part. Please see part 5, it's the miscellaneous part. And then we have the schedule. After 5 parts, we have the schedule, right? Where the period of limitation is given, and it's divided into, schedule is divided into 3 divisions: first division, second division, and third division. First division relates to suit, second division relates to appeal, and third division relates to application. There are model forms also in the act, but not to go through that. Yes. Can you all see, students? Please comment if you cannot see. Please comment if anyone cannot see, and if to everyone my screen is visible, then please see the parts. How many parts are there? There are 5 parts, and then we have the schedule. Right? Now let me come to the parts. Okay. So in preliminary, we have 2 sections, 1 and 2. In part 2, we have from section 3 to section 11, right? This is part 2 of the act. Part 3, if you see, it's from section 12 to 24. 12 to 24 is in part 3. Part 4 is 25, 26, 27, 25, 26, 27. Part 5 is 29 till 32. And then we have the schedule, right? Okay, till now is everything okay? Because I've just given an overview. Is everything okay with everyone? Or do you have any doubt? Please tell me if you do have any doubt. Anyone having any doubt? Please tell me. Okay, so do you think this act is the first act on limitation, or was there any act before it? If anyone knows if there was any act before this 1963 act, or this is the only act till now, what do you think? Anyone who can give me the answer? Yes, students. Please give me the answer to this. Is this the first act? Okay, so I'm not getting an answer in the chat box also from anyone. I can see some people here. Can you please tell me, is this the first act or no? Before that also there was any act before Limitation Act 1963, if there is any act? Yes. Yes, students. You can write in the chat box. Yes, Prachi, right. So there was this act of 1908. 1908. Yes, correct. Yes. So after that only this act 1963 came. After 1908 act, some problems were found which were not catering to the needs of the society and to the thing. So there was lot of controversial discussion relating to Limitation Act 1908. Therefore, on the recommendation of Law Commission third report, it was repealed and Limitation Act 1963 came into existence. And this bill was passed by the parliament. It received the assent of president on 5th October 1963, and it came into force on 1st January 1964. If you see the short title, extent and commencement side, if you see the you know if you see the act, you will see that the commencement is from, it shall come into force on such date as the central government by notification in the official gazette appoint, and it was brought into force on 1st January 1964, but it was repealed by Limitation Act of 1963 as it received the assent of president on October 5, 1963. Right. Now coming to the section, just see, these are really important. I've already in the starting given you the important sections, but when you see this 5th October 1963, what is this? This is the date on which it received its assent, right? And it was enacted, but it came into force on 1st January 1964. Remember that also. Now there are some definitions, but these definitions are, you know um, really important. If it might come in MCQ, they might ask where is applicant defined in Limitation Act. So please write section 2 clause A, which defines applicant. If you see section 2 clause B, it defines application. Section 2 clause C is bill of exchange, which includes a hundi and a check. Section 2D is bond. 2E is defendant, 2F is easement. Now, coming to 2 clause F, if you see the definition of easement, this is important definition because it includes a right not arising from contract. So, though we don't have a contract between us, right, but still you are having a right against me or my property or something. So, I have a pond in my land. So the pond is actually on my land. But you have been drawing water from my land since 20 years, more than 20 years. You have been drawing water from my land peaceably without any interruption. And then you get a right over this drawing of water, fishing, not over my land. Of course, you're not getting a right over my land or on that pond actually, but you are getting a right to draw water if you were drawing water, or fishing rights from that pond, because you have been continuously doing that for a very long period. And if you are doing that within that period, then you get a easementary right. But we don't have a contract between us, but still you are getting that right, by which one person is entitled to remove and appropriate for his profit any part of the soil belonging to another, or anything growing in or attached to or subsisting upon the land of another. So this is really important. 2 clause F defines easement, which is a right not arising from contract. Remember that. And a person gets entitled to, appropriate or to remove anything from that land for his own profit, right? For his own profit, he is doing this. Foreign countries defined in 2 clause G, 2 clause H defines good faith, 2 clause I defines plaintiff, 2 clause J defines period of limitation, as I have already told you. 2 clause J. 2 clause J defines period of limitation, which I have already told you when I was discussing the object, that period of limitation for any suit, appeal, or application by the schedule is the period of limitation which is prescribed in the schedule. And prescribed period is also defined in section 2 clause J, that is the period of limitation computed in accordance with the provision of the act. Then come to 2 clause K, it's promissory note. 2 clause L is suit. So suit does not include appeal or application. Remember this also. 2 clause L, which is suit, does not include an appeal or an application, right? Then come to 2 clause M. 2 clause M, that is tort. Okay, 2 clause M is tort. It's a civil wrong which is not exclusively breach of contract or breach of trust. Tort is a civil wrong which is not exclusively breach of contract or breach of trust. Then 2 clause N defines trustee. 2 clause N defines trustee, which does not include a benamidar, a mortgagee remaining in possession after the mortgage has been satisfied, or a person in wrongful possession without title. Please go through this section and learn it by heart. Section 2 is actually very important. Okay. The definition section of any statute is important. It might come where is, where is easement defined, where is period of limitation defined. So please remember, 2 clause F defines easement, 2 clause J defines period of limitation and prescribed period, 2 clause L defines suit, 2 clause M defines tort. Come to part 2, right? Part 2 is again important, as it is limitation of suits, appeal, and application. And section 3, if you see, section 3 is again an important section which I have told you at the starting only. This section, bar of limitation. Now, section 3 is actually subjected to or controlled by section 4 to 24, right? So if you see section 3, bar of limitation, it is actually subjected to or it is controlled by section 4 to 24, both inclusive. Every suit instituted, every appeal preferred, and application made after the prescribed period has to be dismissed, although limitation is not set up as a defense. So even if you don't set up limitation as a defense, it is going to, your suit, appeal, or application after a prescribed period is going to be dismissed by virtue of section 3 of Limitation Act. Please see section 3 once. So when we talk about section 3, we are talking about bar of limitation, which is what? Which says that these things are going to be, suit, appeal, and application are going to be dismissed if you come after a prescribed period, although limitation is not set up as a defense. And for the purpose of this act, what is a suit? For the purpose of this act, when is a suit set to be instituted, or when is an appeal set to be preferred, or when is an application set to be made? A suit is instituted only in an ordinary case when the plaint is presented to the proper officer. So in ordinary case, we say that you have instituted a suit if you have presented the plaint to the proper officer. In case of pauper, when his application for leave to sue as a pauper is made. And in case of a claim against a company which you are going to wound up, only when the claimant is sending his claim to the official liquidator. So these are the cases where a suit is said to be instituted, right? In case of set off, on the same date as the suit in which set off is pleaded. In case of counterclaim, on the date on which counterclaim is made in court. Where is set off and counterclaim in CPC, students? Do you know what is set off and what is counterclaim? Who can tell me what is set off and what is counterclaim? What is set off and what is counterclaim, students? What is set off? What is counterclaim? Yes? Anyone? Very good, Prachi. Right. Order 8. Very good. Order 8 talks about written statement, set off, and counterclaim. Right. So if you see set off and counterclaim, you will see that, if you want to recover money, or you also the plaintiff is claiming money, but the defendant also has some money with the plaintiff. So the defendant can go for a set off, right, to recover his amount from the plaintiff. And set off is a statutory defense. It's a statutory defense, right? So if, say for example, if the plaintiff is claiming 20,000 from the defendant, right, and he is 20,000 rupees from the defendant, and B, the plaintiff is also, say for example, stating in his written statement that a decree is passed against A because A has not given 15,000 rupees to B, to the to the defendant. What can happen? The court can set off the case. It can set off the case. So here in section 3, it is saying, now the dates are different. For set off and for counterclaim, we see that the dates are different here as given by the Limitation Act, right? It says that any claim by way of set off or counterclaim is to be treated as a separate wanting to counterclaim, but that will be, treated instituted in case of set off on the same date as the suit in which set off is pleaded. So, if, say, for example, today, if I have filed a suit against you on 1st January, I have filed a suit against you on 1st January, and my limitation ends tomorrow. On 2nd January, my limitation ends. So, on 2nd January, if my limitation is ending and I have already instituted a suit a day before, but I have forgotten in my suit to include set off, which I later include, which I am later claiming. So, on my written statement date, in my written statement date, I couldn't, it was the last day, and so in a rush and hurry, I submitted my WS, but I forgot to claim my set off from the plaintiff. Now in these cases, the court, if I want to set off now, and it is, say for example, I want to set it off on 5th January, the court, will it say that it is barred by limitation or not? And same, if the same thing is there, the same illustration, but for counterclaim, then what will happen? Who can tell me? So I want to set off, but my limitation period is over. I have already filed my suit within the limitation period, that was already filed, but I forgot to claim the set off, which I want to set off now. So will the court entertain it, or will it say no, it is barred by limitation? What do you think? Any answer? So here it says it is going to be treated as a separate suit, and in case of set off, it is going to be on the same date as the suit in which the set off is pleaded. Same date as of the suit in which the set off is pleaded. So even if I'm filing my, yes, Prachi, very good, set off will be allowed. So even if I'm filing my set off after the date of, after the date of limitation, after the period is expired, but मैंने तो अपना सूट पहले ही कर लिया था, तो कोर्ट डेट के मतलब वही सेम डेट माना जाएगा. पर काउंटर क्लेम के केस में ऑन द डेट ऑन विच काउंटर क्लेम इज मेड. तो अगर मैंने जल्दी में जल्दबाजी में मैंने अपना सूट अपना रिटर्न स्टेटमेंट फाइल कर दिया है, राइट, और काउंटर क्लेम करना हम भूल चुके हैं. कल आज मेरा लिमिटेशन पीरियड ऑलरेडी ओवर हो गया, बट थैंकफुली मैंने अपना WS फाइल कर दिया है. Then after 5 days, I remember, shit, I could have claimed my money from him as a counterclaim. So now I go to the court and say that I want to counterclaim against the plaintiff. Will the court allow it? Set off तो चलो अलाउ हो गया, बट क्या काउंटर क्लेम को भी कोर्ट अलाउ करेगा? लिमिटेशन क्या बोलता है? लिमिटेशन सेक्शन 3 clause 2 clause subclause B makes saying that in case of counterclaim on the date on which counterclaim is made, so counterclaim will not be entertained after the limitation period is over. After the limitation of period is over, the counterclaim will not be entertained. Though set off can be entertained after the limitation period is over if you have already filed the suit, already filed your WS within the prescribed period. Okay. An application by notice of motion in High Court is made when the application is presented to the proper officer of the court. So we are talking about bar of limitation in case of suit, in case of appeal, in case of application. So this section is applying to all three: suit, appeal, and application. Remember that. Come to section 4, which is expiry of prescribed period when the court is closed. So what will happen when the court gets closed, students? If सोचो आज ही आपका लास्ट डे है टू फाइल एन एप्लीकेशन, बट आज से फॉर एग्जांपल संडे है, या फिर कोई फेस्टिवल है जिसके कारण नेशनल हॉलीडे है, देन व्हाट विल हैपन? According to section 3, it's a bar. Your suit will not be allowed. So say for example your limitation period is ending on 2nd October, है ना? 2nd October को आपका period of limitation over हो जाता है. But 2nd October is Gandhi Jayanti. So you were about to file the suit on that day. Your suit gets ready, but you cannot file it because of some reason, because of the national holiday. So you come to the court on 3rd January and you say, I want to file my suit. Will it be allowed or will it not be allowed? What do you think? If you want to file your suit after the national holiday, because on the last day of limitation कोई national holiday या कोई festival है जिसके कारण, या Sunday है जिसके कारण court is closed, then what will happen? Will it act as a bar of limitation according to section 3, or something else can be done? What do you think? Since it's a limitation act is of public policy, so what do you think about this? It will be allowed. Very good. Why? Because section 4, I already told you, section 3 जो है उसको कौन कंट्रोल करता है? section 4 to 24. तो section 4 जो है, that is something where even if your limitation period is expiring on the day when the court is closed, you can institute your suit, refer your appeal, or make an application on the day when the court reopens. When the court reopens. See section 4 once. Yes. So it says that even on the day when the court reopens, you can file your suit if on the day, on the last day, if the court is, observing some kind of holiday due to some reason, right? So this is based on two principles. If you see section 4, it is based on two principles. I'll show you. Yes. So can you see section 4 is based on following two maxims: lex non cogit ad impossibilia and actus curiae neminem gravabit. So these are the two maxims on which section 4 is based. Lex non cogit ad impossibilia, that means law is not going to make you do things which is impossible. आज संडे है, आज पॉसिबल ही नहीं है सूट फाइल करने को, तो why will law unnecessarily harass you? No, we don't want to make people do something which is not possible. An actus curiae neminem gravabit, which means that an act of court will prejudice no man, right? So this is again the second thing. Now, if you see the explanation to section 4, please see the explanation to section 4. I'm going back to the Bare Act. Section 4 आप देखो. Expiry of prescribed period in court is closed का explanation देखो. A court shall be deemed to be closed on any day within the meaning of this section if during any part of its normal working hour it remains closed on that day. So if it is closed anyway, जिसके कारण it's not like just because it is physically open हम मान लेंगे कि okay आज तो court open था, नहीं. Only when the court is in a working condition. So if it is anyway not working during any of the normal hours, then it is deemed that it is closed. So just because the court is physically open, we won't say that the court is open. If during any part of the working hour you go and then you see that it was not working, so I went to the court, I saw that there was a strike going on and no, nothing is working. So that is a genuine reason and it will be under section 4. You can come next day on the normal working hours, during the normal working hours, and you can file your suit, right? This is section 4. Now section 4 is also very, very important. Come to section 5, which is the most important section of limitation act. आप अगर सेक्शन 5 के बारे में नहीं जानते हो मतलब आपने लिमिटेशन एक्ट नहीं पढ़ा, राइट? सबसे पहली चीज तो ये that section 5 does not apply to suit. This is a very asked question in preliminary examination, that does section 5 apply to suit, appeals and application, all three? No, it does not apply to suit. Please mark it. It only applies to appeal and application. If you see the section, it is only applying to what? It is only applying to appeals and application. So if you see section 5, extension of prescribed period in certain cases. चलो ठीक है, मान लिया आज कोर्ट खुला है, सब कुछ ओके था, फिर भी आपने सूट फाइल नहीं करा, and now you are coming to the court telling that sir please take my suit, please condone my delay. आप मेरी डिले को माफ कर दो. So will the court allow that? Section 5 says yes, it will allow if you have a sufficient cause. So in case you can show the court that you had a sufficient cause which led to the delay, then the court is going to condone that delay and extend the period of limitation in certain cases, right? But that is only in case of appeal and application, not for suit. Mark that also. Section 5 does not apply to suit, and neither is Section 5 giving you an inherent right to claim an extension of period from the court. No, it is a discretion of the court to give you the extension or not to extend. तो अगर आप मेरे पास आते हो, आपने sufficient cause show किया है, and the court feels that yes, this cause is sufficient, so we should extend the time period now, then it will extend. But you cannot claim it as a matter of right. It is the discretionary power of the court to see your cause, make it that okay fine, it is sufficient, and then give you the extension. Now what is sufficient cause? If you see some examples which are held to be sufficient cause is very serious illness, when you cannot even get up from the bed. If you can show all the medical things, that is a good cause. A bona fide mistake, but ignorance of law is not allowed. Bona fide mistake you have done, and then that, that bona fide mistake led to the delay, that is okay. If you have taken a wrong proceeding in a good faith in another court, then also it's okay. We can allow you the extension. Imprisonment in jail is also considered as a sufficient cause, and whatever time you have spent in jail can be condoned. Bona fide mistake in calculation or mistake of counsel is also a sufficient cause. But if you come with the cause that I'm poor and I did not have the money to go to file the suit, it is not allowed. So poverty is not a sufficient cause, because the court gives you legal aid. You can go for pauper's appeal, right, or pauper's application. And negligence of the pleader or the clerk is also not a sufficient cause. So if you're, see, bona fide mistake is okay, but negligence is not okay. So the court, it is up to the court to decide whether your cause is sufficient or not, and to give you the extension. Completely the discretion of the court, right? Come to section 6, students. Now section 6 is again important. It talks about legal disability. If you see, legal disability is being talked in section 6, right? What is section 6? It talks about legal disability. That means you are disabled legally. You are not qualified yet to file a suit or to file a written statement, right? So ठीक है, चलो मान लिया कि आज मुझे किसी ने एक थप्पड़ मारा, and I want to file a suit against that person. I don't want to file a suit, I want to file a, ये तो चलो थप्पड़ मारने will come in the criminal charges. सोचो मेरे घर के पास आज किसी ने न्यूसेंस करा है, एंड सीपीसी के अंदर या कुछ बदमाशी करे, या कुछ लोग मेरे घर पे ट्रेस पास कर चुके हैं, एंड आई वांट टू फाइल, some kind of, some person has just come wrongfully acquired my position, and they are not going from my land. So I want to file a suit against them because they are also claiming they are owner, and it's a kind of civil suit, not yet taken the criminal aspect. So I want to recover my position. In that case, how will I do that? If I am a minor, can I do that? Cause of action to आज से ही start हो चुका है, because it accrues on the date, on limitation period will start running, because cause of action के date से it starts to run. But I'm a minor, so am I anyway able, or I'm of unsound mind? In that case, am I able to institute this suit or application? What do you think? So if any person who is a minor or who is unsound mind, idiot or insane, he or she is said to be legally disabled, and the period of limitation will not run until that disability has ceased. So these are the legal disabilities: insanity, minority, idiocy, or these are legal disability. And the object of section 6 here is to protect the minor and the persons who are suffering from such disabilities. So we don't want to put you under a disadvantaged position where you don't even know how to proceed and how not to proceed. So for that reason, the law says that okay, for these thing, the period of limitation will be ceased for the time period until that disability is, accruing to you. So if that disability ceases, after that you can file your suit. But till the time you are facing that disability or you're under that disability, you are, allowed to stop. The period of limitation will stop for you, and it will start only after the disability has ceased. Now come to section 7. It says about disability of one of several persons. Disability of one of several persons. So if several persons are disabled, not one person, there are several persons are there, and one of them is disabled. So there are 4 5 people, but one of them is not fit. He's a minor or he's of unsound mind, and he's not fit to be in that suit. In that case, section 7 says that if there are several persons who are jointly entitled to institute a suit or to make an application, and one of them is suffering from legal disability, and I can make a discharge without his consent, if I have that right. In some cases, if I do have the right to just discharge the thing without even his consent, in that case time will run against every one of them, even against that minor. So say for example, there are 3 people, A, B and C. Now A is a minor, B and C are not minor, but A is a minor. But B and C, the nature of the suit is that the concurrence of all is not needed. Even the concurrence of one person is sufficient to allow the suit to start. Now, in that case, if uh, you know you don't file the suit during the period of limitation, then it will not happen, because time will run against all of them in such cases where one, the suit can be discharged or something can be discharged without the concurrence of others. Time is going to run against all of them, even against the minor. The minor cannot come after 18 years and tell that I was a minor at that time and I did not file the suit. It was my partners who did not file. The court will say that your partners had the right since they were sleeping. So even you are, suffering, I know, but since they were sleeping, you made them your partner or whatever you have, you took that partnership or whatever. Now it won't happen, because time was running against all of you. But if a discharge cannot be given without the consent of everyone, in that case time will stop to run against all of them. So if one of them, like if it's a minor and his consent is important here, but it cannot be given because of his minority, then time will not run against any one of them, and it will be, it will just stop. So this is section 7. Come to section 8. Section 8 is a special exception. Now, whenever you are reading section 6, 7, 8, you have to read it together. 6, 7, and 8 needs to be read together. So just read once section 8. I'll just drink a little water. Just read section 8. Yes, I'm back. So, see section 8. Now, section 6, 7, and 8 are to be read together because everything is dealing with legal disability. So, if you see section 8, right, it is the special exception. Acha, one thing I want to tell about section 7, if you see the explanation, right, see explanation 2. it says that for the purpose of this section, the manager of a Hindu undivided family who is governed by the Mitakshara law is deemed to be capable of giving a discharge without concurrence of other members. So if it's a Hindu undivided family and it is being governed under Mitakshara law, then the manager can just discharge without the concurrence of other people. In that case, time will run against all of them, right? Special exception, nothing in section 6 or in 7 applies to suit to enforce rights of preemption or shall be deemed to extend for more than 3 years from the cessation of disability or the death of the person affected thereby, the period of limitation for any suit or application. So nothing in this section 6 or in section 7 will apply to suits to enforce rights of preemption. So these are the exception. What is the exception here in 8? That it is not going to apply to suits to enforce rights of preemption. So preemption is an exception, right? So preemption rights are not governed by section 6 and 7, and in spite of the disability, time will run, time will not stop. You cannot come and say I was a minor at that time, I couldn't file my preemption suit. No. So preemption is an exception here. And the second part says the provision of section 6, 7 shall not be deemed to extend for more than 3 years from the cessation of disability or the death of the person affected thereby, the period of limitation for any suit or application. So what is it saying? Second part of section 8 says that if a person is under disability, he can sue after the disability. So time was a stop, but after the disability ceased, now you have become a major, you have to file the suit, you know, within 3 years from the cessation of the disability. So it is not going to extend beyond 3 years. Even you have a lot of limitation period if you were a minor, but it is not going to exceed beyond 3 years from the cessation of disability. Okay, this is section 8. So please read section 7, 6, 7 and 8 together, okay, because that is having a combined effect also. Come to section 9, again very important. It is continuous running of time. So it's a continuation. And what does it say? That once time starts to run, it is not going to stop. Where once time has begun to run, no subsequent disability or inability to institute a suit or make an application will stop it. So if once the time has started to run, a subsequent disability or inability to institute a suit or to make an application is not going to stop it. So it's a continuous running of time. Provided that now there are provisions also where letters of administration to state of a creditor have been granted to his debtor, the running of the period of limitation for a suit to recover the debt shall be suspended while the administration continues. Right? So, once time is starting to run, it is not going to stop. Once it has started to run, it is not going to stop. Remember that. Okay? So, further, if you come up with that, okay, मेरे को एक और disability हो गई या inability हो गई to institute a suit or make an application, no, it's not going to stop it. Right, so the rule is the continuous running of time is is a fundamental principle of limitation law. So I cannot say that after the time has started to after my clock has started ticking, it is not going to stop. So even if you are having any disability or inability in between, no, there is no further break or interruption while the entire period has run out. So no further disability or inability to sue occurring subsequent will stop it from running if once time has started to run. Please remember section 9 also, it is continuous running of time. But there are exceptions. What is the exception? Letter of administration. If letter of administration is granted to the creditor of the state, if the letter of administration of the creditor has been granted to the debtor of the state, then the running of period of limitation for a suit to recover that debt, that will be suspended. So though it is continuous running of time, but if letter of administration is given to the debtor, then time will be suspended while the administration continues, right? So this is one of the exception. Come to section 10. Section 10 is again an important section. Suit against trustees and their representatives. So section 10 is providing that if there is a trust which is created for a specific purpose or for a specific object, I am creating a trust and I have already vested that property in the trustee. Okay, the property is always vested in the trustee. The beneficiary can bring the suit against the trustee at any time without being barred by limitation laws. So law of limitation is not going to, you know, bar the beneficiary of this suit, of this trust property, to bring a suit against the trustee of the property. And this section was enacted with the purpose that, uh, apparently fraudulent trustees who are putting trust money in their own pocket cannot escape the penalty or cannot escape the law by reason of lapse of time. So the beneficiary has the option, has the right to bring the suit against the trustee and their representatives at any time. It is not barred by limitation. Hope this is clear to everyone. Right? So apparently fraudulent trustee cannot take the thing. So if I give you an example, so say for example, I have created a trust for a charitable purpose and I have delivered the position also to the trustee. Now he is doing nothing. The purpose for which I had created the trust is not being executed by the trustee, and I also did not take any action. I was also sleeping over my rights. I was like, okay, he will do, करेगा वो, कल start करेगा, ऐसे करते करते काफी time चला गया. That the one who created the trust also died, right? And the person who created the trust, his son is now filing a suit against the trustee that, this is a fraudulent thing and he's doing nothing, so I want redelivery of my property. Say for example, after 30 years I'm coming and I'm telling my son is coming, or I'm coming and telling that if I'm not dead, I'm coming and telling that this person is not doing anything, I want redelivery of my property from him. Will the suit allow it? Will it allow? It will be allowed, right? It will be allowed. Why? Because if a trust is created for a specific purpose which is charitable, which is for public, and that is not being fulfilled, or it has become vested in the trustee and he is doing nothing, then a suit can be brought against the trustee or even his legal representatives. First, I will bring the suit to enforce the trust, that okay, enforce it, and it is not going to be barred by any length of time. So the suit of T is within time and it is not barred by law of limitation, right? It is not barred by law of limitation. So we don't want that the trust property goes into the hand of any person who is misusing it, and that is why section 10 is given. Now come to section 11. Yes, section 11 is suits on contract entered into outside the territories to which this act extends. Now tell me one thing, student, is Limitation Act Lex Loci or Lex Fori? Anyone who can answer this, is Limitation Act Lex Fori or Lex Loci? So if you see section 11, right, see clause 1. It is a legislative enactment coming from the international law, and it says that all suits has to be brought within the period prescribed by local law of the country where the suit is brought. Otherwise, the suit will be barred. So section 11 is a legislative enactment which says that all the suits has to be brought within the period of the or within the period prescribed by local law of the country. Otherwise, it is barred. And 11 clause 2 says that it is again following the English common law and preferring lex fori, right? Because it says that the foreign law will extinguish the right or obligation itself, and both the parties have to reside in the country where such law prevails for the whole of the prescribed time. So section 11 is making it that limitation act is lex fori. If you see properly, you know what is lex loci and lex fori? Yes, Lakshita, very good. What is lex fori, Lakshita? Can you tell me? And what is lex loci? So lex fori is the law of the country in which the action is brought, and lex loci contractus is the law of the country where the contract is made. So limitation act is lex fori because questions of limitations are essentially the matters relating to procedure, and they are governed by the law of the country where the action is to be brought, where we are coming up with the action. So that makes my limitation act lex fori. So this is part 2. Part 1 we already did. I told you all the content part. Part 1 is the preliminary part. Part 2, which is from section 3 till section 11, is relating to सूट्स अपील एंड एप्लीकेशन. प्लीज सी कि कौन सा सेक्शन किसको अप्लाई करता है. लाइक सेक्शन 2 इज अप्लाइंग, सेक्शन 3 इज अप्लाइंग टू सूट्स अपील एप्लीकेशन ऑल, राइट. सेक्शन 5 if you see it does not apply to suit. So ये सब भी आपको ध्यान रखना है when you are reading the section. These are important sections. मैंने आपको 14 important sections आपको बता ही दिया. वैसे भी इतना छोटा एक्ट है, उससे भी मैंने आपको फिल्टर आउट करके 14 सेक्शंस बता दिए हैं जिन्हें आपको मिस नहीं करना है, राइट. नाउ कम टू part 3, which is computing the period of limitation. When I'm doing computation of period of limitation, how am I going to do that? Right, so come to section 12, which is exclusion of time in legal proceedings. Exclusion of time in legal proceeding, right. So if you see this section 12, which is exclusion of time in legal proceeding, what is it, student? So this section talks about those time periods when you are calculating your period of limitation. This is the computation, okay. This follows the rules and regulation that how are you going to compute and how are you going to take out the limitation period. तो आपको किस किस चीजों की ध्यान, किन किन चीजों की ध्यान रखनी है when you are computing the period of limitation. Section 12, if you see, it says 12 clause 1 will say that when you are computing the limitation period for a suit or for an appeal or for an application, then the day from which such period is to be reckoned is going to be excluded. So say for example, if I am taking a loan, okay, and I am promising that I will return the loan before 1st January or within 1st January of 2024. मैंने आपको प्रॉमिस करा कि 1st January 2024 के अंदर अंदर आई एम गोइंग टू रिटर्न योर मनी, बट आई डू नॉट रिटर्न यू द मनी ऑन द सेट डेट, then the limitation period for recovering money is 3 years, right. If you see, the maximum period of limitation given in the articles is 3 years. For some there are 12 years, for some there are 30 years, for some there is 90 days, 60 days, 2 years, 1 year also. लेकिन मैक्सिमम चीजें आपको 3 साल ही मिलेंगी. तो जिन जिन चीजों का जो लिमिटेशन पीरियड 30 इयर्स, 12 इयर्स या डेज में है या 1 ईयर, 2 ईयर है, आप प्लीज उसको फिल्टर आउट कर लेना कि ये और उसको ही याद करना है कि इसका 1 ईयर है, इसका 2 ईयर है, इसका 30 इयर्स, इसका 12 इयर्स है, इसका 90 डेज है, 60 डेज है, 10 डेज है. आपने लर्न कर लिया. अगर इससे बाहर कुछ आता है तो आपको पता चल जाएगा कि उसका लिमिटेशन पीरियड 3 साल है. ठीक है, यही वो बॉक्स है जहां जहां पर limitation period is not 3 years. So please make a box of which, you know, those suits जहां पर limitation period is not 3 years, because बाकी सारा का आपको maximum 3 years ही मिलेगा. Now I did not return you the loan on 1st January also. So cause of action for filing the suit will arise from 2nd January and not on the date on which the cause of action arose. The date on which the cause of action is arising is being excluded when you are computing the period of limitation, right? Or from the day on which that period of limitation should be reckoned. Second clause says when you are computing the period of limitation for an appeal or for an application for leave to appeal or for revision of judgment or for review of judgment, then the day on which judgment is pronounced and the time which is required for obtaining the copy of the decree or the sentence or order appeal from or sought to be revised or reviewed shall be excluded. So again, it is saying that when you are computing the period of limitation prescribed for an appeal, you have to exclude what? The day on which the period begins to run. Just then the period will start running, will be excluded. The day on which judgment is pronounced is going to be excluded. The day on which, the time which is required for obtaining the copy of the decree or sentence or order is excluded. The time required for obtaining a copy of judgment is also excluded. And if you are prescribing an application for revision or for review, then you have to exclude these days: the day on which the time begins to run, the day on which the judgment is pronounced, time required for obtaining a copy of decree, time required for obtaining a copy of judgment. And when you are computing the period of limitation for an application for leave to appeal, then the day on which time begins to run is to be excluded. The day on which judgment was pronounced is to be excluded. The time required for obtaining a copy of decree is excluded. The time required for obtaining a copy of judgment is also excluded. If you want to set aside an award, you are wanting to find and you want to file an application for setting aside an award. In that case, the day on which the time begins to run and the time required for obtaining a copy of award is to be excluded. This is what is section 12. So please see that the time required, right? The time period which we are requiring here, that means there should be no delay, and you have to calculate your time period by following the rule given in section 12. That means you have to exclude the day on which the period of limitation reckons or starts, and you have to exclude some time period like for obtaining copy of award, for obtaining copy of judgment, for obtaining copy of decree. All this is also excluded. Now come to section 13. If you see section 13, it talks about exclusion of time in cases where leave to sue or appeal as a pauper is applied for, right? So exclusion of time in cases where leave to sue or appeal as a pauper is applied for. So if you are a pauper, right, if you are a pauper and you want to file a appeal as a pauper, you want to first apply for leave to sue or appeal as a pauper. In that case, the application as given here in section 13 is that if it is rejected, if the time period is rejected, then the time during which the applicant has been prosecuting in good faith his application for such leave shall be excluded, and the court may, on the payment of the court fees prescribed for such suit or appeal, treat the suit or appeal as having the same force and effect as if the court fees has been paid in the first instant. So I filed my application for leave to sue as a pauper, but that was rejected by the court, right? That was rejected. The court said, नहीं आप pauper नहीं हो, आपको court fees देना पड़ेगा. But limitation period तो over हो गया. So it says that you have to, if I'm prosecuting in good faith as a pauper, right? I have good intention, sincere motive, then the time period in which I was, prosecuting in good faith will be excluded, right? Then come to section 14. Section 14 talks about exclusion of time of proceeding bona fide in court without jurisdiction. So if you have started your suit already in a court जिसका jurisdiction नहीं था, but आपने गलती से in good faith आपने कर दिया है वहां पे फाइल, तो जितनी देर तक उधर केस चल रहा था वो पीरियड को भी एक्सक्लूड कर दिया जाएगा व्हेन यू आर कंप्यूटिंग द लिमिटेशन पीरियड, राइट? सो इफ यू आर प्रोसिक्यूटिंग इन गुड फेथ and with due diligence some civil proceeding, right, and it is being prosecuted in good faith which in a court जिसका jurisdiction नहीं है, in that case section 14 says that it will be excluded, right? See section 14 also once, students. Come to 16. Now when you see 16, come to 15 once. Now 15 says exclusion of time in certain other cases also. There are other cases also when the time period can be excluded, right? Please go through all the points on which time period can be excluded, right? And then come to section 16. Now if you see section 16 and if you read both the sections, आपको दोनों ही section same लगेगा fully. Both the sections look same if you see section 16. Every word is same except यहाँ पे a person who would है, यहाँ पर a person against whom. Against and who would ही एक difference है in the whole section, otherwise it is same, right? Otherwise it is same. So section 16 is actually clause 1 is applying to the plaintiff, a person who would, that means the plaintiff. Section 16 clause 1 talks about plaintiff, and section 16 clause 2 applies to defendant against whom. So it applies to defendant. And then we have the exception also which is given in section 3. एक्सेप्शन हमेशा प्रीएम्पशन रहता ही है. आप देखना पहले वाले में भी मैंने आपको बताया कि प्रीएम्पशन इज एक्सक्लूडेड व्हेन वी टॉक अबाउट लीगल डिसेबिलिटी. Similarly, and also here section 16 when we talk about this effect of death on or before the accrual of the right to sue. Okay, accrual effect of death on or before the accrual of the right to sue, the exception is preemption only, right? So if you go through section 16, it is based on the presumption. See, section 16 is being based on the presumption that the legal representative will hold the property on behalf of the deceased. So it is his duty to sue in respect of any cause of action which has accrued after the death of the person, right? Now section 16 is based on the principle that unless there is a complete cause of action, limitation cannot run, and that unless there is a person who can sue and a person who can be sued, there cannot be a complete cause of action. So section 16 is providing that, if a person would have been living and he would have a right to institute a suit or make an application, but he is dying before that right accrues. So if he would have been living, usko mil jata ye right, but because he died before the right accrued, or if a right to institute a suit or make an application accrues only on death of person, then the period of limitation shall be computed from the time when there is a legal representative of the deceased capable of instituting such suit or making such application. And same thing in clause 2 also, but for defendant, right? It is for defendant, and the exception which is given here in section 16 is only for suits to enforce right of preemption. Second is suit for possession of immovable property and suits relating to hereditary office. अगर आप इसका exception देखो, there are 3 exceptions. That is one which applies to suits to enforce right of preemption, suit for possession of immovable property or of hereditary office is my exception under section 16. Come to 17. Now 17 is again a very important section for pre-lee, for mains, everything. Now section 17 talks about the effect of fraud or mistake. What is the effect of fraud or what is the effect of mistake on a suit and on the limitation period? तो सोचो अगर मेरे साथ एक fraud हुआ है. I went to buy a phone, an iPhone, and आई बॉट इट गिविंग द प्रॉपर जो प्राइस है, वो मैंने मार्क्ड प्राइस देखा और मैंने उनको वो देकर फोन खरीद लिया. आफ्टर 2 years आई सी दैट, after 2 नहीं, after 4 years 5 years I see that the phone is not working. So I go to the company, to the service center of iPhone, and I tell them कि आप इसका ये चीज थोड़ा देख लो and ठीक कर दो, सर्विसिंग कर दो. But then I come to know that this is not the original iPhone, right? So the service man says, the service center ka people, they say me that ma'am, this is not an original iPhone, so we cannot make it, आप इसको ले जाओ. And I'm like, how come? See the bill. I paid the whole price for a, which is for an original iPhone. Then how cannot this be an original iPhone and all that? So and so. And then I come to know that the person who sold me was actually a fraud. उसने मेरे को एक नकली फोन आईफोन का बेचा, like एक कॉपी बेचा, and it was not original. So in that case, my limitation period is already over now by the time when I want to institute a suit against him or file a suit against him for the fraud. So will I be able to file or not? What do you think? Section 17 says that if a suit is based on fraud of the defendant or the respondent, or say for example his agent, तो जब तक the knowledge of this fraud is not coming to the person, you have the limitation period running, right? तो जैसे ही आपके knowledge में ये बात आती है कि आपके साथ fraud हुआ है, limitation period हम तब से start करेंगे. It is not going to start just because, from the day when I bought the phone. No. Limitation will start from the day on which I come to know about the fraud. Right? So if in case of any suit or application for which period of limitation is prescribed and it is based upon fraud of the defendant or respondent or agent, or the knowledge of that right or title on which that suit or application is founded is concealed by some fraud or mistake, or if the suit or application is for relief from consequences of a mistake, or I need a document necessary to establish my right, but that is not with me, it is fraudulently concealed by some persons. Yes, Lakshita, very good. Fraud time can be excluded. तो पीरियड ऑफ लिमिटेशन कहाँ से स्टार्ट होता है, मतलब एक्सक्लूडेड भी हम नहीं बोलेंगे. पीरियड ऑफ लिमिटेशन विल स्टार्ट टू रन from the time when the plaintiff or the applicant has discovered that fraud or mistake, or could have with reasonable diligence discovered it. अगर किसी ने मेरे से कोई डॉक्यूमेंट छुपा कर रखा है और मुझे वो चाहिए अपना राइट क्लेम करने के लिए, then limitation will start only from the date when I have the first mean, the applicant or the plaintiff has the means of producing the concealed document or compelling its production. Right? So for fraud people, for people who are concealing and doing fraud, we cannot let them appropriate the property, and वो लोग बहुत रिलैक्स होकर रहेंगे कि चलो ठीक है, लिमिटेशन पीरियड के बाद तो मेरे ऊपर कोई सूट और एप्लीकेशन या केस तो होगा नहीं. तो वी डोंट वांट देम टू सिक्योर फ्रूट्स ऑफ देयर डिसऑनेस्टी. तो we will continue, like the time will run only from the time when we come to know about the fraud or the concealment. This is what section 17 talks of. फ्रॉड एंड मिस्टेक एंड कंसीलमेंट, तीनों चीजों की बात यहाँ पे करी गई है. फ्रॉड, कंसीलमेंट एंड मिस्टेक. नाउ सेक्शन 18 टॉक्स अबाउट एक्नॉलेजमेंट. तो सोचो अगर मैंने आज आपसे पैसे लिए हैं उधार, आपने मेरे को एक लोन दिया है, और एंड आई promised you that I will give you the money by 1st January 2024, but I did not pay you. So now your right to file a suit against me has already, you have accrued it and you can file it. And that is till 2027. ठीक है? So when 2024, 2025, 2026, 2027, 1st January तक you have the limitation period to file the suit. But just before the suit could be, that the suit limitation period can expire, I acknowledge the fact that yes, मेरे पास पैसे हैं, प्लीज आप थोड़ा टाइम एक्सटेंड कर दो. तो इफ आई एम एक्नॉलेजिंग द डेप्थ, In that case, period of limitation will start to run again. So जिस दिन मैंने acknowledgement करी, उस date से वापस से period of limitation will start. Okay. So acknowledgements related, you have section 7, section 18, section 19, section 20, right? So these three sections relate to acknowledgement. 18, 19 and 20 relates to acknowledgement. Come to 21. Now 21 is the effect of substituting or adding new plaintiff or defendant. Okay, 21 relates to effect of substituting or adding new plaintiff or defendant. So what does 21 say? Students, can you just tell me what is 21 talking of? See, sometimes we have to substitute a plaintiff or we have to add a new plaintiff, right? In that case, what is the effect if I want to substitute or add a new defendant, right? After the institution of suit. So suit is already instituted. So will I, and the limitation period is over. So will I be allowed or not to add and substitute? If I want to add a new plaintiff or add a new defendant, or I want to substitute a new plaintiff and defendant, suit shall as regard him will be deemed to have been instituted when he was so made a party. And if the court is satisfied that the omission to include a new plaintiff or defendant was due to mistake in good faith, it can direct that the suit will be deemed to have been instituted on any earlier date and not on the date when he was made a party. So what is section 21 laying down? If I want to substitute or if I want to add someone subsequently, right? So if the suit becomes barred as regard him alone or as regard as other parties also, it's a matter, it can happen, which will have to be ascertained with reference to substantive law, of course, relating to subject of necessary parties. But 21 says that if, after the institution of suit, I want to add or I want to substitute a new party, then the suit will be as regard him will be deemed to have been instituted when he was so made a party. So for that person, it is who is added or who is substituted. For the new person, it is deemed to have been instituted on the date when he was made a party, right? But if the court gets satisfied, okay, omission to add a new plaintiff or to defendant was due to mistake or due to some other reason in good faith, then it can direct that the suit as regard that plaintiff or defendant should be instituted on the earlier date and not on the date when he's made a party. So generally, तो on the date when he's made a party, we will deem कि आपका अभी से start होता है limitation period. But if the court is satisfied that the mistake is in good faith, then it can also direct that okay, up earlier date se limitation period start kar do, right? This is what is the section 21 talks about. Come to 22. Continuing breaches and tort. 22 पे आ जाओ. Continuing breaches and tort. Now this is saying that in case you have a continuing breach of contract, मतलब continuously your tort is or continuously your contract is getting breached, yeah, there is a continuing tort, then fresh period of limitation will start running at every moment of time when the breach or when the tort is committed. So if the tort or if the contract is breached or if the tort is committed every time the new contract or new tort is being done, the breach will continue. So in such cases, the right to sue will arise at every moment of time during which the wrong is continuing, right? So it says that it is day die in diem, that is from day to day. Day die in diem, that is from day to day. Okay. Come to 23. Section 23. Section 23 talks about suits for compensation for acts not actionable without special damage. तो कभी कभी कुछ suit ऐसा होता है that problem has already arisen, there is a problem, but it does not arise just because of the commission. It will only arise when some special damage has been you know done to you. तो मैंने अगर कुछ रॉन्ग करा भी है तो भी आप मेरे अगेंस्ट सूट इंस्टीट्यूट नहीं कर सकते हो अगर आपको कोई डैमेज नहीं हुआ है। अगर आपको डैमेज हुआ है तब आप करो, अगर आपको कोई स्पेशल डैमेज हुआ है तब आप मेरे अगेंस्ट सूट करो, बट अगर स्पेशल डैमेज आपको नहीं हो रहा है तो फिर आप just because I have committed the wrong, you cannot institute the suit against me, right? So in ordinary cases what will happen, time usually runs from the commission of wrong. जैसे ही मैंने wrong commit करा आप मेरे against file कर सकते हो suit, but if the cause of action lies not in the commission or not in the omission but in the special damage, then time will run when the plaintiff has sustained that damage or loss. If the plaintiff has not suffered any damage or any loss, then he cannot institute a suit. The time will not run against him for that purpose. So it will only run when the injury is done to you. So section 23 is not extending or not restricting any period of limitation, but it is talking about compensation in respect of a damage, right? So it is not lying in the specific commission or omission, it is lying in the damage. Now come to 24, computation of time mentioned in instrument. Now here the instrument which is used for computation of time period. Now there are many kinds of calendar. There is Islamic calendar, there is Bengali calendar, there are other calendars also which people follow. But for the computation of limitation period, according to Limitation Act, you have to follow Gregorian calendar. Which calendar needs to be followed? According to section 24, it will only be the Gregorian calendar which we have to use for computation for the purpose of Limitation Act. And Gregorian calendar is the calendar, the British calendar or the English calendar, which is introduced by Pope Gregor 13. Okay. So this is my instrument which I'm going to use. So if a MCQ comes, which instrument is used, and there are many calendars given, Gregorian calendar you have to mention as mentioned under section 24. Come to 25. Now this is part 4 of the section, and it is talking about acquisition of ownership by possession. One thing I would like to tell you is that limitation extinguishes the remedy but not the right, and we have an exception in section 27 that I'll come to. First let us go through section 25, which is acquisition of ownership by possession. मतलब just because आपने पोजीशन ले लिया तो आप ओनर बन जाते हो if certain conditions are fulfilled. तो आपने मेरा पोजीशन लिया, I did not give you the ownership, but because of some time period you also get the ownership. Why? So this is talking about acquisition of ownership by possession, and section 25 is dealing with what? Section 25 is dealing with acquisition of easement by prescription. ठीक है, मैंने easement का definition starting में कहाँ बताया था? Which section and which clause of Limitation Act defines easement, student? Any comment? Which section and which clause? Remember, section 2, clause F, remember, defines easement. So, acquisition of ownership by possession, अगर आप देखो, right? First is acquisition of easement by prescription. So, if the access and use of light or air to and for any building is peaceably enjoyed as an easement or as of right and without interruption for 20 years, remember this time limit. it is 20 year, then this right of light and air is going to be absolute and going to be indefeasible. No one can defeat this right of yours if you know you are using and you have the access to light and air, and that too for a period of more than 20 years. Very good, Lakshita. Yes, section 2F was easement. और इफ यू हैव अ वे और अ वाटर कोर्स, तो पहले मैंने लाइट और एयर की बात की, अब हम बात करेंगे वे एंड वाटर कोर्स का। अगर हम एक रास्ता ले रहे हैं जो हम काफी दिन से यूज कर रहे हैं, या एक वाटर कोर्स को हम काफी दिन से यूज कर रहे हैं, या एनी यूज ऑफ वाटर और एनी अदर ईजमेंट जो हमने पीसफुली और ओपनली इंजॉय किया है और किसी ने क्लेम भी नहीं करा इतने दिनों तक, और हम उसे एंजॉय कर रहे हैं एज एन ईजमेंट एज ऑफ राइट एंड विदाउट इंटरप्शन फॉर अ पीरियड ऑफ 20 years, then that right to way or that right to water course is also becoming absolute and indefeasible, right? So peaceably enjoy means no one is claiming, ऐसा नहीं कि रोज आप झगड़ रहे हो उस चीज को लेके। मैं बोल रही हूँ कि आप मेरे घर, आप मेरे लैंड से पानी नहीं लेके जा सकते हो, बट आप नहीं मान रहे हो, आप आ रहे हो। तो अगर हम बार बार आप इस चीज के लिए आपको बोल रहे हैं या कोई सूट चल रहा है, तो वो 20 years काउंट नहीं होगा। अदरवाइज अगर किसी ने कोई भी ऑब्जेक्शन नहीं करा है, आप ओपनली एंजॉय कर रहे हो, विदाउट इंटरप्शन एंजॉय कर रहे हो, एंड यू आर एंजॉयिंग इट एज अ राइट एंड एज एन ईजमेंट, enjoying it as a right and as an easement, then this right becomes absolute, this right becomes indefeasible, right? Come to section 26, exclusion in favor of reversioner of servient tenement। अब सेक्शन 26 जो है वो बात कर रहा है दैट अगर एक सर्वियंट हेरिटेज है, देयर आर टू हेरिटेजेस, डोमिनेंट हेरिटेज एंड सर्वियंट हेरिटेज। सो अगर सर्वियंट हेरिटेज है, दैट मीन्स द लैंड ओवर विच यू आर इंजॉइंग द ईजमेंट, ठीक है, जहां पे आप ईजमेंट एंजॉय कर रहे हो जिसके आप ओनर नहीं हो। सर्वियंट हेरिटेज वो पार्ट है जिसके आप ओनर नहीं हो, पर फिर भी आप वहां पर जाके वाटर कोर्स, कोई वे, या फिर लाइट एयर, एनीथिंग यू आर यूजिंग, एनी राइट फिशरी, एनीथिंग यू आर यूजिंग, and that has not been in possession of the servant owner, but it is under a lease for a term exceeding 3 years, or it is subject to an interest for life, then the time during which that lease or interest is continuing will be excluded from the computation of period of limitation। मतलब क्या है यहाँ पर कि मैंने अगर अपना लैंड किसी को लीज पे दिया है, राइट, किसी को लीज पे दिया है इन, या फिर किसी को लाइफ इंटरेस्ट पे दिया है, एंड दैट टू फॉर अ पीरियड व्हिच इज मोर देन 3 years, इन दैट केस दैट पीरियड इज टू बी एक्सक्लूडेड। हम उसे काउंट नहीं करेंगे। हम ये नहीं बोलेंगे कि हमने, तो सोचो कि मेरा एक लैंड है और उस पे काफी दिन से आप आकर वाटर लेकर जाते हो, ठीक है, तो यू कम डेली, यू टेक वाटर एंड यू गो, and no one is telling you anything, but that land I have given to a tenant for 10 years, मैंने 10 साल से इसको एक टेनेंट को दिया हुआ है, और आप यहाँ पर पानी 22 years से ले रहे हो। तो उस 22 years के पीरियड में 10 years जो था, जो मैंने टेनेंट को दिया था या लीज पे दिया था, दैट इज गोइंग टू बी एक्सक्लूडेड। सो माना जाएगा कि ये लैंड आपके पास 12 years, आप यहाँ पर 12 years से ही पानी ले रहे हो, एंड नॉट फॉर 22 years, बिकॉज टेनेंट को या लीज पे लेसी को दिया हुआ पीरियड विल बी एक्सक्लूडेड, right? Because I was not there. Agar if I was there, the owner was there, I would have, of course, interrupted in this, he don't take water from my land, but since it was under a tenant or a lessee, he did not care, so this period is going to be excluded from the computation of limitation period, right? So if the servant heritage is not held by the servant owner for that entire period for which you are claiming the easementary right, but it was under lease or under for life interest for a period exceeding 3 years, in that case that period is going to be excluded. Now come to section 27, very 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 important section, extinguishment of right to property। मतलब देखो, कोई भी राइट एक्सटिंग्विश नहीं होता है जल्दी, और लिमिटेशन पीरियड में एक जो पार्ट है वो ये है, जो जनरल प्रिंसिपल है कि लिमिटेशन विल बार द रेमेडी बट इट इज नॉट गोइंग टू एक्सटिंग्विश द राइट। इट मींस इवन आफ्टर द लिमिटेशन पीरियड इज ओवर, आप आउट ऑफ कोर्ट अपना राइट एक्सरसाइज कर सकते हो, बट कोर्ट आपको कोई रेमेडी नहीं देने वाला, कोर्ट के पास रेमेडी नहीं मिलेगी, लॉ पे रेमेडी नहीं है। हाँ, आप बाहर आउट ऑफ कोर्ट आप ले सकते हो, सो यू हैव द राइट बट नॉट द रेमेडी। But section 27 is saying that right is also extinguished, Okay, right is only extinguished. Why? After a certain period. See, at the determination of the period hereby limited to any person, and that period is 12 years, for instituting a suit for possession of any property, his right to such property shall be extinguished. So, if I have a land and that is under your control for a period of more than 12 years, I never come to the land, मुझे पता भी नहीं कि आपने मेरा लैंड ऑक्यूपाई करा हुआ है, राइट? तो क्या होता है इस केस में? My right to that property gets extinguished and you become the adverse owner of this property, and because you are holding the adverse position to this property. So section 21 is an exception. Please remember this. Section 27 is an exception to the general principle of law that limitation bars the remedy but does not extinguish the right, क्योंकि यहाँ पे right को extinguish कर रहा है limitation period. Why? It is establishing a limitation of 12 years between private owners, right? That if you are, after a lapse of certain period, your right is extinguished and the adverse person, the adverse owner gets the position. So this is adverse position. A person is said to hold the property adversely when the person, is enjoying the property and he's kind of in a hostile position, right? These are adverse position. 28, 29 and 30 अगर आप देखो तो it is amendment of certain sections और उसी पे बात हुई है. Section 28 says that there are certain amendments in this, and due to this amendment, in like say for example, it was provided that in Indian Easement Act 1882 वाला में अगर आप देखोगे section 15, 60 years is substituted by the word 30 years, है ना? ये सारे कुछ कुछ amendments बता रहे हैं. And also like CPC का 1908 section 48 is going to be omitted. Section 29 is my saving section, right? Just go through it. 30 is provisions for suits for which prescribed period is shorter than the period prescribed. This is again important. You can just go through for the calculation. If the period of limitation is prescribed period is shorter than what is prescribed by Limitation Act. And we have 31 provisions as to barred or pending suits and 32 which is repeal. Now if I show you the schedule, I have already discussed with you that the schedule, we have 3 divisions of schedule: first division, second division, third division, right? First division deals with suit, second division deals with appeal, and third division deals with application. So my schedule is divided into 3 parts: first division, second division and third division. First division is suit, second division is appeal, third division is application. ठीक है? आपका काम ये है कि जितने भी 3 years and 12 years और 12 years 30 years या days वाले हैं, उनको आप filter out कर लो, ताकि बाकी सारी चीजें आपको याद है कि बाकी सारा आपको 3 years ही बिठाना है अगर period of limitation आ जाता है तो. And first division जो है suit, that is again divided into 10 parts. And all this 10 part, if you see from section 1 to from article 1 to 50 to 60 तक तो आपको 3 years ही मिलेगा. आर्टिकल 1 से आर्टिकल 60 तक सारे पीरियड ऑफ लिमिटेशन 6 years 3 years ही है. पार्ट 5 में अगर आप आओगे, पार्ट 6 में अगर आओगे, वहां पे आपको थोड़ा डिफरेंस मिलेगा, 1 year 2 years 3 years वाला, तो वो आप देख लेना पार्ट 6. ठीक है? पार्ट 7 में भी आपको कुछ 1 year और 2 years मिल जाएंगे. पार्ट 7 में भी, पार्ट 8 में भी आपको मिलेगा. सो यू विल गेट सम डिफरेंसेस इन पार्ट 6, 7, 8. ओके, 9 is it's only for part 6, 7, 8 and 9. Just see which are the different periods. Otherwise for everything it is 3 years. सेकेंड डिवीजन बहुत इंपॉर्टेंट है. इसमें आप देख लेना आर्टिकल 114 टू 117 है, तो इसमें डेज में भी है 90 days 30 days, वो आप देख लेना. और थर्ड डिवीजन जो एप्लीकेशन है, दैट इज इन स्पेसिफाइड केसेस. वी हैव आर्टिकल 118. दैट मीन्स फॉर ऑल अदर थिंग्स इट इज अगेन डिवाइडेड इनटू 2 parts. ठीक है? फॉर अदर एप्लीकेशन इट इज 3 years. एंड पार्ट 1 अगर आप देखो, इन स्पेसिफाइड केसेस आर्टिकल 118 टू 136 इट इज 10 days 30 days, ऐसे 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 है यहाँ पे. So the last article here is 137. For other applications, it is 3 years. But please go through this. Make a chart, filter out. आपको filter करने की ज़्यादा ज़रूरत नहीं पड़ेगी क्योंकि आप बस देखना part 6, part 7, part 8 and part 9 for the differences जहाँ पे 3 years नहीं मिलेगा. सेकेंड डिविजन अच्छे से पढ़ना है और थर्ड डिविजन का part 1 एक बार देखना है. बाकी सारी चीजों के लिए 3 years ही है शेड्यूल. Right, students? So please go through the act. I have already discussed with you the important sections जो मैंने आपको दिखाए स्टार्टिंग ऑफ द क्लास में ही. वो आप एक बार देख लेना, बिकॉज फिल्टर आउट करके पहले ये पढ़ लेना, ये सारे सेक्शंस जो मैंने आपको ऑलरेडी डिस्कस करा है, और कुछ इंपॉर्टेंट मैक्सिम्स डिस्कस करे हैं. गो थ्रू दैट ऑल्सो. 14 सेक्शंस या 15 सेक्शंस मैंने बताए हैं जो इंपॉर्टेंट है अमंग दिस 30, तो मैंने उसको भी हाफ कर दिया है. वैसे आपको सारा ही रीड करना है, बट इन सेक्शंस को थोड़ा डिटेल में पढ़ना है और इस आर्टिकल का सारा प्रॉपर पढ़ना है कि ये किस चीज को लेकर है और इसका क्या लिमिटेशन पीरियड है. राइट? So we can end this session now. Thank you so much, students. Thank you for your patience. All the best for your exams.